Hey, I'm live again. Welcome to my live. I'm trying to become an expert or somewhat of an expert on going live. So the only way to improve on going live or anything else is to just do it. Hopefully I can provide some value to the people that tune in, and I'll do my best to continue going live at least once a week into the foreseeable future.
Elephant stomping in the courtroom, great elephant defending the innocent, mind sharper than a tenement, criminal defense, ain't stronger than cement. Out here wrecking cases so your time may spent. Suits clean as a glass, arguments intense. Great elephant in the zone, watch you commence. Skipping past objections, mind so immense. Law books tattered, but the flow never fixed. Rapping legal, heavy on the blocks. Great elephant, got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock. Tell the judge to relax, swaying the parole. Jury nodding heads, great elephants control. No sweat under pressure, ice in his soul. Not a cuff, break free, legal as his goal. Late nights grinding, paperwork and stacks. Great elephant, beats flexing facts. From the trenches to the marble floors.
So let's
Straight
jump right
facts,
in.
criminal defense, kingpin, never falling back. Trapping legal, heavy on the blocks. Great elephant, got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the
See
clock.
what kind of activity we got. Right now it looks like it's just me. There's no party like a party of one, so won't y'all jump on this live with me. I'm going to share this link in the live. If you want to join and you have a comment you want to share or you have a question you want to ask, you can click the link to join. And I will bring you on stage to ask any question or questions that you may have. All right, so let's talk about Mr. Baldwin. And to do that,
When the sawdust settles and the engine finally roars.
we're going to go through some testimony that came out in his case. Not testimony, I'm sorry, I misspoke. Not testimony, but arguments by the lawyers and rulings by the judge that could significantly affect the direction the case goes in. So let's let this commercial play and then we'll play this clip. All right. Here we go.
Was filming a Western movie entitled Rust in Bonanza Creek, New Mexico.
Now let's slow the speed down. We can't be playing this at 1.5 and understanding what they're
Baldwin was rehearsing a scene with director Joel Souza and cinematographer Helena Hutchins. Baldwin was seated in a church, practicing a cross draw with a .45 caliber revolver. As he practiced pulling the weapon from the left side of his body, with his right arm, the gun discharged. The bullet struck Helena Hutchins and Joel Souza. Souza survived, but Hutchins did not. The first assistant director and the movie's armorer have already been sentenced for their roles in the death of Helena Hutchins, and now Alec Baldwin's trial for involuntary manslaughter is moving forward. And today, for the first time, Alec Baldwin appeared in court for a motions hearing. Tonight, we're on the ground in New Mexico.
So this video is brought to us by Court TV. You know, this case is very, very interesting. The first thing that comes to mind is how is this a crime? How is this a crime? You know, is it negligent? Yes. Should somebody, Alec Baldwin, the other people involved, be held liable in a civil court for money damages? Absolutely. But do we really want to criminalize accidents? Or, you know, this person was really, really negligent in his handling of a firearm. Do we want to criminalize that? You know, that's a good question to be asking now in Louisiana, especially because 18-year-olds, as many of you know, beginning on July 4th, 2024, 18-year-olds can now carry a concealed firearm without a permit. But I digress. I don't want to go there. It's something that I'm sure there will be lots and lots and lots of discussions on going forward. So we're gonna focus on clips in this video. So I'm gonna go to 1 minute and 30 seconds, and we're just gonna hear a little bit. We're gonna just hear a little bit about what's actually about to occur in court before we even get into what's occurring in court.
Tonight in New Mexico, where actor Alec Baldwin made his first court appearance during a pretrial hearing in the involuntary manslaughter case that's against him. Today, the judge ruled in on several motions with two notable wins for the defense. The judge ruled that Alec Baldwin's role as a producer on the set of Rust was not relevant to this case against him, and that the trial is now going to focus on just Baldwin's conduct as an actor in this situation, how he handled the gun the day that Helena Hutchins was shot and killed. The judge also ruled that there will be some restrictions on videos of Alec Baldwin, videos we saw during the other trial in this case that could have been shown to this jury. No more. Prosecutors can present video evidence they say shows Alec Baldwin being reckless while handling guns, but they will not be permitted to show the jurors other videos, like ones where Baldwin is rushing the crew members on set, telling them again, re-rack. Now, let's look back at some of the big moments from today's hearing in our daily wrap.
So here we go. We got Mr. Baldwin. So what is a motion? A criminal motion is just, I guess, movement. You know, you're motioning the court, you're asking the court to make a ruling on typically an evidentiary matter. Can we discuss X, Y, and Z at the trial? Is this piece of evidence admissible? Can this witness testify? Just a motion. You need the court being the judge, the court being the judge. You need the judge's help getting you to a certain point or helping you achieve a certain outcome before the case proceeds to trial in front of a jury.
As the court is aware, there have been multiple civil lawsuits filed against Rust Production and against the defendant himself. Mr. Joel Souza, one of the state's witnesses, filed a civil lawsuit that I understand, has since been settled. There are 3 other states' witnesses, or 4, I believe, other states' witnesses who have pending civil lawsuits.
Your Honor, the defense has no present intention of questioning Mr. Souza about his settled lawsuit. This cross-examination was done during the Armour's trial, as the court no doubt remembers. In that case, there was 0 financial motive. In this case, there is a suit against Mr. Baldwin directly, an extreme financial motive.
These different videos show the defendant acting.
So this is interesting, and this is important, and this is an issue that comes up in pretty much every criminal trial. Motive, like the credibility of every witness is always important. As a criminal defense lawyer, you always get to challenge the credibility of the witnesses. Is this person believable? Is this somebody we can trust? Should we rely on what is coming out of this person's mouth when it comes to determining whether or not somebody should go to prison? And then there's bias. What bias does this witness have? What are their motives for testifying? Clearly, the witness who has a pending civil suit has a financial motive. And I would imagine that civil suit will be much easier to win in court if he's able to show that Mr. Baldwin was convicted in criminal court. Because what many people don't realize is that the burden of proof in a criminal case is beyond a reasonable doubt. It's beyond all reasonable doubt. So that burden is much, much, much harder to reach in a criminal case than it is in a civil case or an injury case or a case for money. So if he loses the criminal case, it's going to be very difficult for him to have a chance in a civil case. And at the same time, the person who's suing for money in that civil case has motive to testify against him in a criminal case, and that motive being money. And there's not much of a bigger motivator in this world than money for a lot of people. So let's see what else happens in this hearing. The next thing the prosecutor, I'm going to play the clip in a second, there was a issue about the prior handling of a gun. Mr. Baldwin has been known for poor handling of weapons. So let's hear what happens and let's see what the judge rules on that issue.
In a wanton and reckless manner. These are inextricably intertwined with what he did on October 21st, when he pointed that gun at Ms. Hutchins, cocked the hammer, and pulled the trigger.
The state told you what it's going to do. It's going to try to show recklessness before and therefore recklessness on October 21st. It cannot do that by showing what happened before is an indication of what happened after.
So denied and granted in part.
Because the jury's going to hear about what...
So the judge basically said, we're not going to allow you to bring that in. You can't bring in every instance that this man may have been poor in his ability to handle a gun or the manner in which he handled a gun. There's really no probative value, meaning it's not beneficial to the jury, and it's going to be entirely prejudicial because what he may have done 3 months, 3 weeks, 3 years prior has nothing to do with how he did or did not handle the gun on the date of this fatal shooting. And then we get into his status as a producer. This is kind of interesting. I believe the prosecutor here is just grabbing for straws. The goal with the next clip that you're going to see is that the prosecutor is attempting to use the fact that Alec Baldwin is a producer, and I'd imagine in the movie industry, there's some rules and regulations and trainings and whatnot that producers have to undergo to make sure they operate their movie sets in a safe manner. And the prosecutors want to use this to support their theory that he was negligent in causing this lady's death.
Producer does, they're going to hear about the producer being the boss, the buck stops with him, etc. And the risk is that they think Mr. Baldwin's responsible for what he did on the 21st because he's the boss, he's the CEO, he's in charge.
I am calling Mr. Jorgensen to come in and talk about the producer's responsibility with regard to set safety. And Mr. Jorgensen is acutely familiar with this, because he actually teaches producers what their responsibilities are and how they can have a safe set and avoid getting sued for killing someone.
The probative value is not substantially outweighed by unfair prejudice and certainly confusion of issues to the jury.
So you hear the judge? Unfair prejudice and confusion. So even though the evidence that he is a producer may be relevant, if it's unfair prejudice, or confusing, it can still be excluded. So everything that's relevant, people, doesn't mean just because a piece of evidence is relevant, that does not mean it automatically comes in to evidence in court in a trial. The probative value has to outweigh unfair prejudice or undue influence or anything else that the judge determines makes this piece of evidence just over the top. I'm not going to allow it. It's gonna do more harm than good. It's going to do more bad than good. If the judge weighs that, he or she can exclude evidence, even if the evidence is relevant. You know, a side note, too, with this whole producer trying to get in the fact that he was the producer, you know, that, I could see that coming in a civil case. In a civil case, a personal injury case, we have what's called corporate liability. You are responsible for the acts and the negligence of, except for intentional acts, but you're responsible for the negligence of your employees if they're untrained or undertrained or not sufficiently trained, or they don't operate their job in a safe manner, then you can be liable, vicariously liable for the actions of your employees. Now, I've never seen that happen in a criminal case, but it appears that they're trying to use the fact that he was a producer to put this corporate veil over Mr. Baldwin and use that in an attempt to bolster their case that he's guilty of involuntary manslaughter. And the judge just didn't go for it. And I think that was a good ruling. That was the appropriate ruling. That was the fair ruling that was needed in this situation. And my hat's off to the judge for making a tough call on an important issue in this trial.
I'm denying evidence of his status as a producer.
All right, so this is finishing up the producer, but the judge, there's an interesting, the next deal we're going to deal with is the prosecutor's concern that the defense may attempt to attack her and the prosecution. So let's hear this out.
I am concerned that there will be, throughout this trial, numerous allegations that the state has engaged in misconduct and trying to deprive the defendant of his right to a fair trial.
This is not going to be a trial about the ethics of the prosecutors. It's not going to be a trial about they should have dismissed the case a long time ago. They did. They took it back. Well, none of that's coming into this trial. No intention. What we intend to do is exactly what I discussed we were going to do with Schilling, for example. We're allowed to demonstrate that bias, improper motive, incompetence of the government investigation.
The court agrees that the prosecutor's misconduct as alleged by the defendant in his pretrial motions may not be brought out at trial. The misconduct is not relevant evidence, and even if it were, its probative value is substantially outweighed by the danger of unfair prejudice and confusing issues.
Same thing. Danger of unfair prejudice and confusing the issues. The judge is simply saying, Mr. Defense Attorney, Mr. Defense Team, Mr. Defense Attorney and Defense Team, I will not allow this trial to be you attacking the prosecutor. Now, that doesn't mean they don't get to attack the prosecutor's evidence or lack of evidence or the way the evidence was gathered or the way the evidence is presented. I think the judge ruling is simply a personal attack, accusing the prosecutor of expressly doing something wrong. There's a number of issues with that. Number one, if you believe a lawyer violates the Code of Professional Responsibility, you're obligated to report him or her. So the defense lawyer, if they believe this prosecutor in fact violated an ethical rule, he's bound and obligated to report the prosecutor. While at the same time, I understand the judge's position. The case is not about the prosecutor. It's not about the defense lawyer. The case is about the actions that occurred on this date that resulted in a lady losing her life and whether it fits within this plain reading of this New Mexico statute for involuntary manslaughter. So then there's a pretrial ruling concerning witnesses and what they can or cannot testify to. So I'm going to play the clip, and then we'll talk about the judge's ruling from a legal standpoint.
Absolutely be able to come in and say, I noticed that Hannah Gutierrez wasn't doing her job because Mr. Baldwin has told everyone Hannah Gutierrez was a stellar professional.
They can only testify about what they observed on set, in this set, and what they observed on other sets, provided that they have a sufficient history to do so. However, again, we're going to have to decide relevance.
So the judge ruling there is, a witness typically cannot give, a witness other than an expert witness, such as a medical doctor, some sort of scientist, those witnesses are allowed to give opinion testimony. It's outlined for them in the Code of Evidence. But typically a lay witness, a fact witness, is limited to testifying on the facts. What did you see? What did you hear? What did you smell? They don't get to come in court and say what they believe happened or what kind of person they believe them to be, especially when it comes to actions. There's some stuff when it comes to knowing somebody's general reputation where you are allowed to say, I know this person's general reputation. He's a good person. She's a bad person. But there's a specific evidence article for that. When it comes to opinion, just a blanket opinion, a fact witness is not allowed to do that. And the judges, it appears this judge is going to give some leeway because it's impossible for the judge to know exactly what each and every witness is expected to say. That's typically within the realm of the lawyers, and even then we don't know. People get on the stand all the time and surprise us with things they say that we're hearing for the very first time. So, nevertheless, you at the end, you heard the judge say we're still going to have to look at this and see if it's relevant. Because evidence to be admissible, the first hurdle is that it has to be relevant. If it's not relevant, it's not admissible. And that's just that simple with any piece of evidence you ever try to introduce in any trial, criminal, civil, family. There's no relevance, you shouldn't be talking about it. So, now I want to talk about, this is a big issue. There's a fight about discovery, which is evidence, not being turned over. This is a big issue, not only in this case, but I'm going to say in pretty much every criminal case that goes to trial, there's a chance there's going to be a fight over evidence that either was not turned over or the parties cannot agree on what is or is not admissible. So let's take a look at that. All right, here we go. 9:45.
against that, saying that's just not true. We don't know what more we can do here. Why don't we go ahead and listen to some sound from inside the courtroom today?
Initially, we had been corresponding largely with Ms. Morrissey, who had been the prosecutor on this case for quite some time before Ms. Johnson came on. Our requests for production and our concerns about it looking like we had incomplete discovery, like it looked like we had incomplete disclosures, were constantly met with, you have everything, there's nothing else to give you, or if you tell me specifically what you're looking for out of these, IPRA productions that are redacted, tell me specifically what it is that you want unredacted, and then I'll take a look. What we did was, realizing that we were getting nowhere, again, after all of these months, we had dealt with IPRA to try to take it upon ourselves, even though it's not our obligation, to try to get more documents. Those came in over the course of about 7 months, again, heavily redacted, and we could tell that there were some documents that certainly appeared to have the type of content that we would be entitled to. But many of them had, entire sections that were just completely blacked out, so we don't know what the content was at all. We could only see, who the sender and recipient were, and everything was blacked out. So we were left to guess, whereas the state has the affirmative duty of disclosure. And so what we did was then we, for the first time, I believe it was on the 27th of June, reached out, and instead of emailing both prosecutors or just Ms. Morrissey, we reached out directly to Ms. Johnson, and only to Ms. Johnson. And basically, under her obligations as a prosecutor now on this case, asked her to fulfill those obligations and do an affirmative review of everything and to turn over anything that needed to be turned over. The same day, in accordance with her responsibilities, she did then respond and said that she was requesting a full unredacted copy of the thousands of documents that we received under IPRA that were still redacted, and that she would undertake an affirmative review of those items, as well as checking for an audit with the law enforcement agency. That same day, after she responded to us with the request that we had just sent her, again earlier in the same day, we started to already get disclosures where Ms. Johnson was saying, I've found documents that are subject to disclosure under Rule 5501, contrary to what we had been told from the inception of this case, which was that we had everything that fit under 5501.
The state has complied. I did receive the request, and Ms. Morrissey didn't have the unredacted IPRA. I requested the unredacted IPRA. We went through all of those documents and made those disclosures. They have the information, and the information that they want is information they're not entitled to.
You're going to have to make arguments on why the redacted portions of the IPRA request that she has kept redacted are fair game. And this is all about IPRA, is what I'm understanding.
There's statements that were obtained, yes, Your Honor, emails. There are thousands of pages of emails. And so, Your Honor, the proper remedy, they haven't shown how they're prejudiced.
So obviously you can tell the court is not happy with this. We are in recess. Go confer, and I'll see what's going to happen. I will give you an hour.
Thank you.
We're in recess.
All right, so we can see here the judge is not happy with the prosecutor in this situation. Now, what is IPRA? There's a IPRA, and it's in every state. We have a Public Records Request Act in Louisiana. But IPRA under New Mexico law is the Inspection of Public Records Act, IPRA, IPRA. It's a New Mexico statute. It's a New Mexico state law that provides the public access to public record. The law requires open access to almost all public records in state and local government, with a few exceptions. So, this statute is in place not only for criminal cases. The media uses this to get access to information, but specifically in criminal cases, the defendant has a right to have all evidence in his case, including exculpatory evidence. Exculpatory evidence is evidence which tends to show innocence or lack of guilt. inculpatory evidence is evidence which tends to show guilt. So whether evidence is inculpatory, shows guilt, or exculpatory, shows innocence, the defendants are typically entitled to this. And they're entitled to it unredacted, because who's doing the redacting here? Is it the prosecutor? Is it the police? What are they redacting? How and why should they get to determine what should be redacted and what should be turned over to the other side? And then there's a lot of talk about missing items. So this is a trick prosecutors play all the time. You go to court. For instance, we have open file discovery in Louisiana. They give you a copy of the file. They say, "I've given you my entire file." Those are buzzwords. If your lawyer's ever told that, he or she needs to look more. If the prosecutor says, "I have given you my entire file," what we typically say here is, "I don't just want your entire file. I want everything." So here's a classic example. I'll get a set of discovery, 100 pages, 200 pages, 500 pages, 1,000 pages, 2,000 pages. Doesn't matter. Something's always not in the file, in the open file. So I'll read through a report, and they'll mention several officers wearing body cameras, other officers taking photos, other officers on the scene. However, inevitably, all the body cam footage is not turned over. All the photos isn't turned over. Evidence that was collected isn't turned over. And so let me clarify that. A lot of times they'll collect fingerprints, DNA, other evidence that they believe may be evidence of a crime. They say, "We've collected items 1, 2, 3. We're going to submit those to the crime lab to have them tested, analyzed, compared to other DNA samples." Well, if your lawyer doesn't ask for it, there's quite a few times that it just sits in an evidence drawer somewhere, never tested, could be exculpatory, could prove somebody's innocence, and it just simply hasn't been turned over because the prosecutor doesn't read the file like a defense lawyer, and they're not there to help us. And the defense lawyer didn't do his job by reading the file and looking for what's not there. That's one thing I tell my clients. When I get your file, I do a preliminary review of it. I have to get it in, or I have to organize it before I read it. I have to number the pages before I read it, because I'm reading it to see what they're saying, what the allegations are, but I'm also reading in between the lines what's not here. As a defense lawyer, what's not there. So Mr. Baldwin's lawyers, they're not asking for anything out of the ordinary, anything they're not entitled to. They just want to have it all. Give us all the evidence. You don't get to cherry pick which pieces of evidence you're going to turn over, because the evidence you want to present at trial may be completely different from the evidence the defense lawyer wants to present. So be aware of that, folks. If you have a family member, a friend, or even yourself is ever in facing criminal charges, you want to make sure everything is requested, everything that you're entitled to. And there's very, very few things you're not entitled to. So, and typically, even if you aren't, we're going to ask for it. Somebody's going to have to tell me you can't get that. So that's that issue. I think the other thing, I touched on this earlier, vicarious liability. That's a concept that applies to civil cases where an employer can be responsible for the actions of an employee. But it comes up in this trial, so let's just play this clip and see how this argument goes.
It's in our nature to be
It's not his fault. He did nothing wrong.
Is there an actor's exemption from liability when they're handling a deadly firearm?
The Alec Baldwin manslaughter trial. Live coverage weekday mornings only on Court TV.
They're trying to hold Mr. Baldwin responsible for what he did as an actor on the 21st because they claim he was reckless as a producer leading up to that time. That's a theory of vicarious liability in the criminal law that is not recognized.
Today was...
That's right. He said what I said. I've never seen that in criminal law. If they want to go to civil court and sue him for a couple $1 million, then it's quite possible he's vicariously liable for the actions of others. But in this case, even so, vicarious liability isn't really the appropriate legal standing. Vicarious liability isn't the appropriate legal statute that I believe would be relied on in a civil trial because it's only in part. The vicarious liability is as to there was somebody who handed him the gun and another person who was responsible for the safety of the weapons on the set. And ultimately, he has some liability for his actions, the actions performed by him. But so there could be some vicarious liability as to those other individuals. However, I'm having a hard time accepting that concept in any capacity in a criminal matter. So what do we have? So it goes on where they talk about evidence, more talk about him being a producer. Let's play that. That's the last clip we'll play today from this video. 23, 25.
Unfolded.
Your Honor, as the court is aware, relevance does not exist in a vacuum. So the evidence that the defendant was a producer is relevant to demonstrate to the jury that as a producer, he is aware of his safety obligations, the safety duties, and there will be evidence of the bulletin number 1, which sets out movie set safety rules and how Mr. Baldwin indeed violated those. I think what Ms. Morrissey indicated in her response is that he did violate New Mexico law. But to demonstrate that the defendant's conduct was reckless on set, the state is also going to introduce evidence that he violated these set safety rules that are in place for actors and producers to follow. It's relevant to his recklessness because we have to establish, again, it's not just in a vacuum, that the defendant's conduct on this set was reckless, and therefore, on October 21st, he should have been aware that his conduct of pointing a firearm at another human being, cocking that hammer, and pulling that trigger is reckless conduct.
I'm having real difficulty with the state's position that they want to show that as a producer, he didn't follow guidelines, and therefore, as an actor, Mr. Baldwin did all these things wrong, resulting in the death of Helena Hutchins, because as a producer, he allowed this all to happen. I think that when you look at the relevancy, I think that one of the reasons why I think I'm having a hard time wrapping my hand around it, to be able to say, Mr. Baldwin, because he was a producer and he was the boss, although there are more than one producer, and he couldn't do anything without, looking at those contracts, he couldn't do a thing without running it by, including hiring somebody, without running it by whatever that entity is in the contract. But I do not believe that it has any tendency to make more probable than it would be without the fact that Mr. Baldwin, individually as an actor, committed involuntary manslaughter through negligent use of a deadly weapon, and the alternative theory. The probative value is not substantially outweighed by unfair prejudice and certainly confusion of issues to the jury. So I'm denying evidence of his status as a producer.
There you go. Can't talk about the man being a producer, at least not in this criminal case. Maybe the civil lawyers suing for money damages can do so, but in this criminal case, no. So we've kind of covered some pretrial issues in the Baldwin case, as well as some rulings, and we're going to stay up to date on the trial itself. I believe the trial has begun. The trial has in fact begun. I'm going to break down the opening statements, and then I'm going to follow the testimony. Some of the testimony will be summarized, and I'll break down my opinions on some of the testimony as it comes out. So that's it for Mr. Baldwin, but it's important. I want to link this to Louisiana law. So just those of you who are or who may in the future face charges in Louisiana, or have family members who will. Many of us have family members who find themselves in need of a criminal defense lawyer. So if you're facing a homicide charges, I would just want to cover some things you should know. First of all, there's 4 major criminal statutes that homicides in Louisiana fall under. First-degree murder, which is the top of them all. You can be given, it's automatic life without parole if you're found guilty of first-degree murder. And they also have the option to seek the death penalty. Second-degree murder, is the only difference between first and second-degree murder is there's no death penalty, but it's still life without parole is the automatic sentence. Next on the list is manslaughter. Manslaughter carries 0 to 40 years in prison. I know that sounds barbaric, and it is, in my opinion. Most states, manslaughter is somewhere around 15 years max, but in Louisiana, the max is 40. And then the baby of them all, or the least penalty of them all, is negligent homicide, which carries up to 5 years in prison. And comparing that to Mr. Baldwin has an involuntary manslaughter, and he's only looking at 18 months. Where here in Louisiana, if you have a negligent homicide, you're going to be doing up to 5 years in prison, which helps explain why we have some of the highest incarceration rates. I think, in fact, I remember a few years back reading that Louisiana has the highest incarceration rate in the world, more than China, more than Russia. Let that sink in. More than China, more than Russia. This little state, the boot, has the highest incarceration rate in the world. So let's talk about if you're facing these charges in Louisiana, what you need to know. So there's a few things you should do right away if you're charged with murder. Stay calm and cooperate. Now, this doesn't mean talk to the police. As you can see, she had this little image has this young lady with her hands around her neck and her X on her mouth. Cooperate doesn't mean give a statement without the presence of a lawyer. Cooperate means if the police say stop, you stop. If they say hands up, you put your hands up. If they say lay down, you lay down. If they say quack like a duck, quack like a duck. And I know that sounds silly, but the reality is, if you have an interaction with the police, I'll tell people like I tell my kids, the most important thing is for you to get home. If they violate your rights, we'll deal with that later. We can't do anything about it on side of the road, some back street, in a bar, in a club. You're not gonna win a verbal argument with the cops. You're gonna only get yourself in more trouble because they'll hit you with resisting arrest. So cooperate with their instructions, but keep your mouth closed until you have a lawyer there to represent you. Don't make any statements. I got ahead of the gun. Look the lawyer in the bottom. Don't make any statements. You can make a statement and say, I'd like to call a lawyer. I like my lawyer. I don't have anything to say without the presence of a lawyer. Outside of that, there's probably not much you should say. You are required to give a few things. You are required to give your name, your date of birth, your address. There's a specific statute that requires you to give those things. So you don't get to say, I ain't telling you nothing. I ain't telling you my name. I ain't telling you where I live. I ain't telling you my address. You're not required to say where you're coming from, where you're going. You're not required to say that. Contact an attorney immediately or as soon as possible. Sometimes, look, if the police pull you over, don't go grabbing for your phone trying to call a lawyer, because that sounds good in theory, but that may get you shot or tased or beat up or something. So contact a lawyer immediately, but realistically that means as soon as you can safely do so. Preserve evidence. If there's any evidence, remember I talked earlier about in Baldwin's case, exculpatory evidence. Evidence that tends to support your innocence or lack of guilt, please preserve it. But nobody else is going to preserve it for you. I can assure you that I've seen more than one case where the police did not preserve evidence. I've even seen them get rid of evidence. So preserve the evidence that you have. If you have any evidence, preserve it. A classic example, guy goes on a date with a girl. They have a good time. They have sex. Girl contacts guy several times after, says, I had an amazing night. When can I see you again? Guy ghosts her. Girl makes allegations. You better save those text messages, because those text messages might save you. Same thing goes for video. If there's video of an incident that shows you did not do what they claim you did, save the video. If there's footage showing you were in a different location at the time a crime occurred, try to get your hands on it and preserve it. Follow legal advice. Now, don't call a lawyer and then go do the opposite. If you call me or another criminal defense lawyer and they give you sound, solid advice on what to do, what not to do, what to say, what not to say, don't turn around and do it anyway. If you're in jail and your lawyer says, don't talk to anybody about me, don't talk to anybody but me about your case, don't talk to your mom on the phone about it, don't talk to your brother, your sister, your cousin, your girlfriend, none of them people, only me. Please don't talk to your cellmate about your case, because he or she will testify against you to get his or her time cut. Your lawyer tells you don't do it. Guess what? Don't do it. People do it anyway, and all you're going to do is complicate an already difficult job. It's going to be hard enough for the lawyer to represent you if you're charged with serious crimes. Don't compound it by ignoring his or her advice. So let's talk about some of the rights and protections for defendants. Obviously, I've beat this like a dead horse. You have a right to remain silent. You have a right to a lawyer. You have a right to a fair trial, and that typically happens during jury selection. Anybody that's discovered to be biased or unable to be fair can be excluded from serving on your jury. You are entitled to the presumption of innocence. Everybody charged with a crime is presumed innocent until a jury says guilty. You are entitled to a protection against double jeopardy. So that means you can't be tried twice. You can't go to trial and get found not guilty and be tried again. You can be tried again, and a person can be tried again if there's a hung jury. Louisiana finally came out of the dark ages and now requires a unanimous verdict in all felony criminal trials, which means everybody has to agree. It used to be during Jim Crow, it was 10-2. Well, it started in Jim Crow, but it didn't die until less than 5 years ago. You only needed 10 jurors to convict a person of a crime, and the other 2 could vote not guilty, 10 vote guilty. The person was going to prison for the rest of their life. That was initially put in place just to minimize, eliminate, make irrelevant the minority vote. 48 of the 50 states have required a unanimous jury verdict as long as I can recall, probably as long as I've been alive or longer. The Supreme Court, the U.S. Supreme Court recently ruled that Louisiana, which was 10-2, and Oregon, which was 11-1, had to get on the ball. If you're going to send somebody to prison, you need a unanimous jury to convict them. So if you get convicted by a unanimous jury, obviously you go to prison. But if you get found not guilty, you cannot be tried again for the same case. If you go to trial and there's a hung jury, they can try you a second time. If the jury hangs the second time, they can try you a third time. The jury hangs the third time, that's right. There is no limit. There is no limit to the number of times a prosecutor can try and retry a person in a hung jury. There's no limit. I've seen them go. I think the most egregious case I saw was the one out of Mississippi. They tried a guy 8 times. But I've seen them do 2, 3, 4 trials of the same person over and over and over again. Just keep taking this man or woman to trial, even though there's mountains of evidence and all sorts of things that are coming out that call into question seriously whether this person might be guilty of something. That's double jeopardy, folks. So obviously, it's important to hire an experienced criminal defense lawyer. Don't just hire somebody who dabbles. Hire somebody who actually spends a significant part of their life, their practice, in court representing people accused of crimes. An experienced lawyer is going to have knowledge and expertise. They're going to know how to investigate the case. They're going to know how to gather the evidence, marshal the evidence, review the evidence, look for evidence that's not contained in the evidence based on what they have. So I get a stack, I'm going to go through it, and part of what I'm doing is noticing what's not there. It takes a certain amount of focus and determination and willingness to just push through all of the games that are played to make sure you can do a good job for your client. And lastly, not everybody goes home right away, but hopefully you're going to go home someday. And it's not always the defense lawyer's job to keep you out of jail. A lot of times the job may be just to minimize the amount of time you're going to go. And that's done by negotiating a plea deal on your behalf. But I always tell clients, I'm going to only get you the best plea deal possible when I've worked your case up. I have to be able to show this prosecutor all the issues they have in their case and all the things that could go wrong for them if this case were to proceed to a jury trial. Once I do that, I'm in a good position to negotiate a good plea deal on your behalf. But if I just show up in court, or any lawyer shows up in court, doesn't file any motions, doesn't have any hearings, doesn't know what's going on, doesn't know your name, how you look, barely knows your charges, and the prosecutor has no incentive to negotiate. Why negotiate when you have all the bargaining chips? If they know they're going to get a slam dunk because the work hasn't been done on the file, then you're going to be in trouble, my friend. So hire a lawyer who has knowledge and expertise, who's going to go out and investigate and gather evidence, and who's willing to try the case if it has to go to trial, but also who'll do what needs to be done beforehand to work out a plea deal if your case has to be pled. All right, there you go, courtroom representation. This is the last, and typically, this is what people look for. People want a lawyer who is a courtroom general. Can you present evidence? Can you call witnesses? Can you cross-examine witnesses? That's the most important thing for a lawyer doing criminal defense work. It's like, if my client has to go to trial, can I get in the ring and fight for him? If the lawyer can't do that, then everything else is going to be more difficult. Working out a plea deal, evidence, prosecutor may be less vigilant in their duty to turn over everything, especially if they know the lawyer's not even gonna look at it, you know. So you want a lawyer who has actual trial experience, actual courtroom experience, is comfortable in the courtroom, win, lose, or draw, because the lawyer that says they never lose is probably the lawyer who's never in court. I lost a hearing last week that I believe I should have won, but I'm not surprised. It was in criminal court, and the deck is stacked. But we live and we fight another day, and at the end of the day, if the case goes to trial, I will trust the jury because they have no other desire than to get it right. I believe that when a jury shows up, their biggest desire is to get it right because they want to go home feeling like they made the right decision. You need a lawyer who can present your case in court to a jury. And then the last thing I believe a criminal defense lawyer provides is emotional support and guidance. Now, this doesn't mean we're going to hug and cry together, but I'm going to understand your case. Anybody that does criminal defense and takes it serious, they're going to understand your case, what you may be going through from an emotional and psychological standpoint, probably better than most people, certainly better than your family members or friends, because we do this for a living. We do it every day. If it's a murder case, then it's not my first, second, third, fourth, or fifth one. I've done a lot of them, and I know the toll this has on people, both the families of the victim and the families of the accused. Most people who find themselves facing these charges, they're humans. A lot of them just found themselves in bad situations. Some were put in bad situations that they did not want to be in. But nevertheless, in addition to defending an individual in court, I need to make it a priority, and I do make it a priority to help them along the journey, because I need them to be strong mentally to help me help them. If they break down, there's going to be no help to their defense. So look for a lawyer. I know we started talking about Baldwin, but we have similar charges on the books, but ours actually carry significantly more time than Alec Baldwin is even looking at. So it's important to know what to look for if you're ever in need of a criminal defense lawyer for yourself, a family member, or a friend for a charge as serious as this. So, that's all I had to share today, offer today. I think I'm going to try to go live every Wednesday. That seems like a convenient day to do it in the middle of the week. But I'm open to looking at other days. So if you think there's a different day that would be more appropriate, a different day and time, because I'm looking at 7:30 on a Wednesday evening. If I can do that every Wednesday, that is my goal. But hey, if I'm open to votes, leave a comment. Let me know if you think I should do it Monday, Tuesday, Wednesday, Thursday. Don't say Friday. It's going to be football season. I have a kid that plays football. But outside of that, give me a night of the week that's best for everyone. And if possible, I will adjust my schedule and go live on that day. If you can't, you can always leave a comment, and I'll still answer it on my next show. Which, if you can't jump on live, you can always watch the recording. You can go back, watch it at your own pace, watch it in parts. Whatever's appropriate for you. Just watch it. Go on YouTube and subscribe. That's where all of the content really is going to live on YouTube. That's where I'm going to branch out, grow, expand on it. Allow a lot more things on YouTube, because YouTube's platform really allows us more flexibility than we can get anywhere else. So with that being said, I got a little song for y'all. Let me know what y'all think about it. And I'll see you guys in 1 week or less.
Great elephant in the court, stomping ground, defending the innocent, justice profound. In the jungle of the law, he stands tall. No case too big, no crime too small. Chains of guilt break with trump and steel. From the boardroom deals to the courtroom field. Clients or objections, silky smooth. Clients breathe easy, knowing they'll groove. Shot like a defense, scales tipped in his favor. Gavels begging, freedom is his flavor. Sweating, opponents guessing. Witnesses' tails twisted like a lesson. Feed his peanuts, but work juggernaut. In court he roars, untangling knots. From mansions to street, he ain't discreet. Every verdict, victory, can't be beat. Great elephant in the wild of the law. Bottomless wisdom, heavy and awe. Unchain the shackles, raise the tusks. Criminal defense, in him we trust. Silent steps in the courtroom corridor. Barks louder than a hard-nosed matador. Clients backed, defense taxed. Criminal defense, in him we trust. Silent steps in the courtroom corridor. Barks louder than a hard-nosed matador. Clients backed, defense taxed. Prosecutors trapped, his skills jacked. In the courtroom's tall and bright, great elephant stands with might. Justice served both day and night. Great elephant in the light. Wears a suit that's always neat. Every client he will greet. Victory never feels defeat. Great elephant can't be beat. Great elephant, fighting for the right. Great elephant, shining true so bright. When the gavel strikes the wood, great elephant is all he could. Wins the battles like he should. In the law he's understood. Always calm and always fair. In the courtroom with a stare. Great elephant does declare injustice won't be spared. Great elephant, fighting for the right. Great elephant, shining true so bright.
on going live or anything else is to just do it. Hopefully, I can provide some value to the people that tune in, and I'll do my best to continue.